Today I wanted to talk about the I-601A provisional waiver, also known as the extreme hardship waiver. This waiver is required in the following circumstance: where a U.S. citizen has married a non-citizen and wants to petition for that spouse's green card. You can apply for a green card, that the spouse qualifies for permanent residency. However, if that non-citizen spouse is in the United States and entered the country without inspection, meaning he or she entered the United States without a visa or without some other authorized entry, then that spouse cannot apply for the green card in the United States. They have to go back to their home country to do what's called consular processing and apply for the green card there. Now that scenario causes a catch-22 because in most cases, if a spouse has been here in the United States and entered without inspection and has been here for more than a year, then a 10-year bar will apply. So by leaving the country, that spouse triggers a 10-year bar where he or she cannot come back to the United States legally. That causes an obvious problem with a married couple. They don't want to be separated for that long. And so we have what's called this provisional waiver that solves that problem. Now before 2013, you had to apply for that waiver out of the United States in that spouse's home country. Now that was problematic for a couple of reasons. One is if the waiver was denied, then that spouse would possibly be subject to a 10-year bar. Or even if the waiver was applied or was approved, it could take a long time to get it approved, and there's a long period of separation. And so in 2013, this new provisional waiver was started that lets you apply for the waiver here in the United States. And that's a wonderful advantage because you don't have the period of separation, and you know that if it's approved here, in most cases you can safely have your spouse go back to their home country and apply for their green card. Now you need to make sure there are not other issues. In other words, there are not things that would make that spouse inadmissible other than their unlawful entry. But as long as there aren't, then this waiver is great and it works miracles in a lot of situations. But I would advise that if you're considering this, you should use an attorney. It's a complex process. There are a lot of things that can trip you up. And like I said, you want to make sure that there's not other things that would cause problems in your case. And it's not necessarily an easy thing to apply for. The standard is extreme hardship, and just that term alone, extreme, shows you that there's a lot you need to prove. However, I've filed for those several times. I've had a lot of success, and we can get those approved, but I would recommend you talk to an attorney to do that.